Does the Oklahoma Court of Criminal Appeals interpret penal statutes strictly against the state? I'm also attorney James Wirth, and that is the question that we have. It has to deal with statutory construction. We're dealing with the massive power of the state versus the lack thereof of a defendant, and interpreting the statutes that are passed by our legislature, signed into law by our governor. How are they to be interpreted? And not just in Oklahoma, but anywhere pretty much in the United States, there is this general policy that penal statutes are to be interpreted strictly against the state and liberally in favor of the accused. So if there is a debate on the meaning of something, because we have to give notice to the populace of what is illegal and not illegal, this defendant has to be given the benefit of the doubt. And it has to be super clear if we're going to charge somebody that that was a crime, so that, we live in this fiction where everybody's presumed to know what the law is, and therefore they can be prosecuted for it even if they don't know, because we're going to presume that they do know. That fiction kind of loses its meaning if we don't have this statutory interpretation where we interpret the statute in the favor of the defendant as opposed to the state if there's any ambiguity, because otherwise then we can't presume that the defendant, everybody knows what the law is if it's not even clear what the law is. So does the Oklahoma Court of Criminal Appeals still follow this? And I would say, based on decision that we've seen over the last 10 years, they've gone very much away from where they were previously in enforcing the rights of the accused and the people, and going the other direction. We're starting to see some pushback from that from one or more of the judges, but not the majority. The majority of the whole, as a whole, seems to interpret it the exact opposite, sometimes what appears to be bending over backwards to secure convictions and working more in the favor of the prosecution than in protecting the rights of the defendant. But what I'm talking about today deals with a recent case. It's Washburn versus State of Oklahoma. It is a published case, 2024 OCCA 9, and that had to do with the interpretation of whether a particular crime is an 85% crime or not. And there's a list of 85% crimes. It's actually Title 21, Section 13.1. They're all specifically listed, but there's a little bit of ambiguity on one because it references a certain type of crime in a statute, and when you go to that statute, it has more than just that specific crime. So the court had to decide whether those other crimes listed in there, related crimes, are also 85% crimes or not. And the court went ahead, and seems like that they were giving the benefit of the doubt to the state rather than requiring that the law be super clear on what is an 85% crime and what is not. And we have a dissent on that issue from Justice Rowland. We can provide some information on. It says, the second problem with interpreting the 85% rule to cover all Section 1123A crimes is that it violates our long-held statutory principle that criminal laws are to be interpreted strictly against the state. It says penal statutes are to be interpreted strictly against the state and liberally in favor of the accused. The majority is persuaded by the fact the legislature has not clearly stated the 85% rule does not apply to all crimes in this section. But to me, that gets the analysis backwards. So he's right. That's exactly what the Oklahoma Court of Criminal Appeals majority is doing. They are giving the presumption to the state. They are interpreting it in favor of the state, rather giving the benefit of the doubt to the accused or to the people. And it's violating a long-held statutory principle, and we're seeing a lot of decisions that seem to do that. But this is one where at least one of their own, one of the judges called it out, although that was in a dissent, not the majority opinion. So the law as of today is that statute is being interpreted broadly to include all the crimes in that section, even though they're not specifically listed in Title 22. Section 13.1. So if you're dealing with criminal prosecution in the state of Oklahoma, you have a question about criminal defense, you're going to want to talk to an attorney privately and confidentially to get legal advice and actionable advice for your circumstances. To get an appointment scheduled with an attorney at my office, you can go online to makelawEasy.com.